All right, so very shortly we're going to start a court hearing on Bryan Kohberg, the state versus Kohberg, on June 18th, 2025. And I'm going to go ahead and watch this in real time, putting it on the screen. In fact, I'm going to put that up now, but I wanted to give you a little bit of a heads up. We're going to put this on screen so that you can at least see what's coming up. This is the court will begin soon. Notice we're about maybe 10 minutes away from the airing. I'll do some editing on this video so that it is shorter in time. But what we anticipate happening, let me cover a little bit about what we anticipate happening. So recently there was a Dateline NBC episode that was aired, The Terrible Night on King Road. In that episode, there was never seen before footage that was bragged about by Dateline NBC multiple times. They indicated that the FBI had given them information that they had never been seen before, that there was several details in that episode that had never been heard before or seen before. After the episode, Stephen Hippler, the judge in this case, who, by the way, has been pretty much always showing at least that he doesn't really believe that there's much of a case for the defense and that this is kind of a slam dunk and kind of has been treating it that way. He was actually hot, in my opinion, in writing about after the Dateline NBC special, saying that somebody that is clearly involved with law enforcement or the prosecution, either formally or currently on the case, has leaked information to the press, specifically to the Dateline NBC piece, because there was pieces of information that came out in that episode that clearly show somebody with inside information on the prosecution or law enforcement side has been leaking information. Now, granted, right off the bat, NBC told us that the FBI had leaked information to them. So did it come purely from the FBI? I don't know. Did it come from a law enforcement insider who works with the FBI? Possibly. Did it come from the prosecution itself? Possibly. Did it come circuitously through Steve Gonsalves, who seems to be opening his mouth all the time and oddly enough has kind of stopped opening his mouth since Stephen Hippler blew a gasket, I should say, on the Dateline NBC thing and said, I want to know who leaked this information. I'm going to punish them. This is the only way we can have accountability. This may have cost us the trial, as far as a ton of money on the trial, I should say. There's no indication they're going to throw the trial out or the case out, but he said it is going to cost the state of Idaho more money. They're going to have to sequester jurors. Probably they're going to take longer time during voir dire process to be able to get a jury selected that hasn't been tainted by all the hit pieces that come out. So we expect to hear about that today. The seating of the jury as we know it today, I believe, is supposed to begin on July 30th. By the way, 2 more hit pieces are coming out before that. July 11th, I believe, is a Amazon Prime special about Idaho, and that's going to be a hit piece produced in part by James Patterson, the famous writer. And then James Patterson himself, along with a co-author, I believe, named Vicky Ward, will be coming out with a book on, I think, July 16th. These were just 2 weeks essentially before the jury selection process starts happening on July 30th. Whether or not Hippler is going to mention the upcoming documentary or book by James Patterson or not, I highly doubt it, but it would be interesting. I'll be paying attention if that does happen. What he should, in my opinion, rule on is he's going to tell us in this, I expect what's going to happen today, is he's going to tell us whether or not we are on pace to have that trial begin August 11th like it's supposed to be, whether jury selection is going to start on July 30th as we expect it to be. I guess I would anticipate that because he's already hinted that the selection process for the jury may take longer because of this hit piece that came out, that we may push the August 11th date back. However, I think Hippler wants to have that court trial be done before Christmas. It's going to be anticipated a 3-month trial, which is going to take us out through November, late November. I think Hippler wants to have it done by Christmas so everybody can go home. If he pushes it out much further, even a couple of weeks, we're going to bump into Christmas time. And then that's going to create a lot of logistics, hardships for families who are on the jury who have to miss Christmas if they're sequestered. So that would mean that there's a potential for the whole entire trial to be pushed into 2026 instead of happening this year. I don't anticipate that's going to happen. I think all intents and purposes that Hippler has got a calendar set. He's already made arrangements for his own personal conflicts of interest to make sure that he can be there for the trial during the 3 months that he said. Every indication is that Hippler has no intention to move the trial. However, we know that he was hot about this Dateline NBC episode that aired, and that there were going to be repercussions and that it may impact the trial. So the big surprise today could be moving of the trial date. In addition, what I anticipate happening is some kind of announcement of repercussions, whether or not it has been discovered who the leak is, announcements perhaps of who's been punished, who might be removed from the case. There is a possibility that a prosecutor in the case may get removed if they were part of responsible for the leak to the press. Those things could come out in today's hearing. So this could be a monumental court hearing, or it could be a no, never mind. It could be a, hey, getting together, trial's going to proceed as scheduled, have a good day. That's highly unlikely. I anticipate a little bit of some shockers and some fireworks on this episode as we get into it, which is why I decided to go ahead and do a recording. I was going to do it live, but I decided rather than do it live, what I'll do is I'll try this method. I've never tried it before. I'm going to actually air the broadcast. Hopefully you're going to hear the audio on my screen when it comes out. And then I will pause it. I think we can pause the live stream as I have comments. What I don't want to do is I don't want to walk all over the broadcast. For those of you, and this is the reason why I didn't do it live, just to let you know. For those of you who are watching live, you may not appreciate my constant commentary, constant pausing the audio, where you're getting further and further behind where the rest of the nation is watching it live. If you're one of the people who have FOMO, the fear of missing out, you would rather watch the whole thing in its entirety so that nobody can surprise you by saying, oh my God, you haven't seen that yet? That happened like 20 minutes ago. So those of you who can't stand that, go watch the live feed, or you actually, because of the way I'm doing this, you will have already watched the live feed if you were that kind of person. So that's why I decided to do it this way rather than live, pausing it all the time and having you get frustrated that we're getting behind on the national audience. So this is going to be aired after the hearing is over. I'm planning on doing my full analysis as we go live, pausing the camera, the stream many times, as long as they allow me to pause. Now, again, this is the caveat is going to be whether or not I can pause the live stream. I believe I can pause the live stream and get behind, which will allow me to talk about things that I heard and explain things to you. I'm going to take this video as a presumption that you're familiar with the case, but you may not know everything. So if I feel like the general audience may or may not know something, I might spend a little bit more time with it. But there are going to be things that I believe you already know. Let's talk real briefly while we're waiting for the feed to begin about the key players. Stephen Hippler, he's going to be the bald guy on the stand. He's gonna be presiding over this most. We're probably going to see him a whole lot. We've got Ann Taylor, of course, the blonde attorney for Bryan Kohberg. She will have co-counsel with her, probably 2 females next to her that are also on her team. There are others on her team as well, like investigators. You'll probably only see 3 people at the counsel bench. I don't have those names, and it's not important right now, of her co-counsel, one of which I believe is a death penalty specialist that will probably be there. And then on the other side, you're going to have Bill Thompson, Jennings, his one of his cohorts, and there'll be another individual, probably 3 at the I would suspect 3 attorneys also at the prosecution bench, which will be Bill Thompson. He's the big gray-haired guy, lead prosecutor, and then his team over there on that side. So that's who you're going to see, the key players. They may be announced, of course, as they're brought into court and all these things begin to see, but that's who the key players are. So you're going to probably see Bryan Kohberg on screen. Obviously, he's been at his hearings. He'll be there next to his counsel on the defendant's table. He will remain silent the entire time. The courtroom will have people in it. It's a very small courtroom. Again, for those who don't know, I'm planning on attending the court in person in Boise, Idaho. It's relatively near to where I'm at. I'm making plans on it right now. In fact, I've got reservations for the first week of court, but I expect that those reservations may be changing today, because if we find out that the court has postponed the trial into next year or a couple weeks or whatever, I got to make some new travel arrangements. So I've already got travel arrangements. I'm planning on going down there. Just to let you know, while we're killing time, why would it be beneficial for you to watch my channel during the trial? Well, as you can see here, we're planning on broadcasting the trial, and I think the whole trial will be broadcast just like you're seeing here on this website. You can follow this as well. This is the State versus Kohberg. Idaho 4th District Court is the channel. You want to subscribe to it just like I did. I clicked on the subscribe notification down there. That should be the same place that they're going to broadcast this entire trial in theory. Now, what's the difference between being in person and being in trial while we're killing some time? What you're going to see on here is you're going to see the counsel benches, that's the defense and the prosecution, and you're going to see the judge, and you probably will see witnesses on the stand. You will never see the jury. You might see shots that contain people in the audience. It's a very small courtroom. Again, at the courtroom, by the way, I didn't explain this earlier, there's an overflow room for people who want to attend in person but can't fit into that little tiny courtroom. So there's an overflow room. So it's going to be as if you are in the courtroom. It's just extra seating. Now, here's the difference between the stream, I believe, this is what I believe, the stream that'll be shown in the overflow room is going to be different than the stream that you're going to see on TV. Meaning, the stream that'll be in the overflow room, I believe, will be just like what you would be seeing if you were in the courtroom. The cameras will be on the jury. You'll be able to see the jury themselves. You'll see their faces. You'll see reactions. You'll see exhibits. For example, graphic crime scene photos and stuff like that and images might be displayed where the everyone inside the courtroom who's there present, including the overflow room, will see it. You will not likely see any gruesome photos on the live stream here that you're going to see on the internet. So being in person allows me to get my eyeballs, in theory, my eyeballs on the actual crime scene photos, as if I was a jury member. It is possible, it is very possible that juries and sometimes in some cases will be allowed to see photos that even the courtroom's not allowed, but Hippler's already indicated that the public is not going to accept the verdict in this case unless they see the evidence for themselves. So I suspect that Hippler is going to allow the court, at least, those who showed up to trial in the courtroom, to see the evidence for themselves in limited fashion. Those in the masses will see it, of course, on the live stream, just from without seeing the jurors. Now, what am I allowed to talk about inside the courtroom? If I'm there and I do get to see the jury, I'm allowed to tell you things in general, like the jurors seem to be checked out during this part of the presentation. They seem to be bored. They were really engaged in this part of the conversation. Those kind of things I can talk about. I can even give you a general breakdown, 6 women and 6 men. Now, we know that there's going to be, there was, last we heard, about a 20-person jury, 12 of which are going to be the actual jurors, and 8 of which will be alternates, for a total of 20. The alternates and the jurors won't be determined until the actual deliberations, which means that all 20 people have to pay attention with the idea that they are going to be asked to make a verdict. All 20 people will have to look at this case as if they were making the decision at the end of the trial. When it comes time for deliberations, they will have some kind of system that will, whatever, lottery wise or whatever, pick which one of the 20 are going to, actually, I think they're going to be determined ahead of time. They'll announce which ones of the 20 are the actual 12 jurors. The others are alternates. Those alternates are in place for many different reasons. Sometimes a juror can't make it through the whole case. They have to get dismissed. Sometimes a juror does something wrong and they speak to somebody in the hallway and they have to get dismissed. They break the rule about not watching any newscasts about it, and so they have to be dismissed. Sometimes they get sick. Sometimes a family member dies. There are lots of reasons in which a juror may have to be removed. So they already know who the 12 are, for example. 8 of those people who don't know that they're not on the jury, they're just alternates, they're going to be slotted in if one of those 12 can't make it for some reason. So when it comes time to deliberations, they're going to announce who the 12 people are. And unfortunately, for those poor bastards that were alternates, you just spent your entire time watching the trial for nothing more than educational purposes, because you're not actually going to be rendering a verdict. You're just going to go home, kind of thing. Now, they may keep the alternate jurors sequestered. I'm not sure as well. During that process, in case something happens during deliberations. But in theory, only 12 people will be deliberating on the case. If it goes to the death penalty phase, if they decide that Bryan Kohberger is guilty and they go to the death penalty phase, typically is that the same exact jury will then be re-impaneled. The same 12 people that made the verdict will be re-impaneled to then determine whether or not death is the appropriate penalty for that. So there'll be a guilt phase, which is the first part of the trial, and then there'll be the penalty phase, if you will, basically determining what the punishment should be. So that's kind of an overview of how that would happen. Again, I'm just trying to give you a little bit of a heads up as I understand the court system. As a heads up as well, while we're killing time, Ali Benevento is an attorney friend of mine that I've been having on the show many times on Devil's Advocates. She's a defense attorney of 15 years from South Carolina. She is interested in this case. She is interested in my take on the case. She's going to be coming on periodically during the case to discuss with me every day's trial proceedings, but we're probably going to do her once a week. So at the end of the week of a week worth of trial, I'll be taking notes throughout the week, and then I'll get together with Ali for a get together and say, hey, here's what we saw during the court sessions today. or this week, and we'll talk about some things. Allie May, if she has time, she's a very busy attorney, so she's busy herself, and she's got her own trials going on potentially at that time. So she will try to probably catch my daily update at the end of every court session, at the end of every court day. I intend to try to do a 30-minute or less recap of the major findings. I'll also do longer form videos for people who don't want just 30 minutes, because I can ramble like you have seen right now. I haven't stopped talking since we started this. I can do this all day. I can do this all day long. Anyways, point being is that we'll do some lives. We'll all talk about this in more depth. We'll do some more long form videos. I also am still going to be covering Luigi Mangioni's case and the Idaho4 Beach. I'm anticipating that's a new case that I'm starting. Well, it's not a new case. It's a new case for me. I anticipate following the Idaho Beach murders as we move forward into trial on that one. Those trials, Idaho Beach, that's Rex Heuermann's case in New York, as well as Luigi Mangioni in New York. Those cases are probably going to happen sometime in 2026. So we're going to focus this year on Bryan Kohberg. But I can't stop watching all the pretrial evidentiary hearings, information stuff that's going on in both Luigi Mangioni and Rex Heuermann, the Idaho Beach murder case coming up in New York. So I'll have to cover all that as well. So I have a busy schedule. I'm trying to get better and better at my content. I'm rebranding all of my thumbnails so that you can quickly see which case it is that you want to follow, and hopefully with my thumbnail, based on whether it has a green background or a red background or a blue background, you'll know which one of the three cases that it pertains to, and can more quickly subscribe to the playlist that you want. Because some of you are watching multiple cases that I follow, and some of you are only interested in one. And I've repeatedly told by some people I have zero interest in the other cases you follow. I'm trying to make it easier for you to follow just the case that you want to follow. So settle in. I'm just at this point, I'm just rambling. I don't know how much I'm going to cut out of this before I post this online. I apparently am allowed to have hours and hours, and maybe 10 hours or unlimited hours of recording. So we're at 16 minutes of recording just to get started. The feed hasn't started yet. It says it's live down here. So they are live streaming. But they're just on a splash screen. Court is in session. Now, this is not uncommon during any kind of proceeding of the trial. The attorneys will probably all go into the courtroom. The public will be seated in the courtroom. The judge will be waiting until he's been told that the court is in order and ready for him, and then he will come in. Typically, that's when the feed will begin. So all that pre-stuff, while they're filing into the courtroom, setting up papers, getting things ready, waiting for the judge to arrive, that's probably happening right now behind the scenes. We're waiting for Hippler to walk into the courtroom, at which point, if all things go well, and it hasn't gone well so far, a lot of hearings have had all kinds of technical difficulties. So we will hope that as soon as this screen comes on live, that we have a technical issue, that I have it set up right, that you're seeing the right screen, and that when it comes on, you're going to hear the audio. That's what we're hoping is going to be the case. And that's all predicated on whether or not they have done it right, and they get their camera turned on and the audio working and we can hear them. So bear with us if we have technical difficulties. When the feed first comes on, we'll probably see the courtroom. We'll probably see the judge entering the courtroom. If I don't hear sound, I have to quickly find out if the sound issue is on my end or on their end. So we're going to have some technical glitches to work out as we get going. So again, buckle up, grab a soda. You only have a few minutes. I think we are past time right now. So court is already supposed to be in session. Again, they may be doing some filing in and getting everybody settled for the judge to come in. I anticipate that we are that's happening on that side right now. So we're just waiting for them to turn the cameras on and see how it goes. All right, I'm just checking some quick notifications. All right. So as you can see, I just did the full screen. I didn't have the full screen option, so some things it seems like has changed on their end. I didn't have the option to make it full screen for a while, but I think as soon as they went live, and I just didn't catch it right away, it was just saying upcoming. Then it went to a live status, so they're broadcasting. I think when it did that, I was allowed to do what I just did, is I clicked on a button to make it full screen. So in theory, if I hover over it, you can see down there that we're in the live broadcast. The volume's all the way up. It should be playing. So we're just, again, waiting for the court to come into session. I think we're in good shape. I'm going to hover my mouse over here because I'm going to have to, from time to time, pause the audio as I want to comment on something. So my mouse is now positioned in place. I'm positioned in place. My soda is positioned in place. My camera, my microphone. Shit, I think we're good. No cats are in the room. Oh shit, I left the dogs outside, which means the dogs are right outside my door, which means that they can and often will interrupt the audio at any given time with tons of barking, and they never stop. So that was a mistake of my part, because I really don't feel like I can get up and go to the other room, put the dogs in the garage, although I probably could. I'm contemplating it. Shit. I don't want to miss the start of the trial, so I'm not going to do that. I mean, I could hit pause right now on the feed and then go take care of the dogs. If the dog, that's what I'll do. If the dogs start barking crazy in the middle of this audio, I will pause the live feed, go take care of the dogs, and come back and resume the live feed. That'll take care of that, and we can fix that in editing. So there you have it.
Judge Stephen Hippler presiding.
All right, we're live. Hopefully you can hear it. Hippler's in the upper right, of course. Defense counsel upper left. Lower is Bill Thompson and his co-counsel.
All right, this is CR 0124316665, State v. Kohberger. On behalf of the state, we have Mr. Thompson and Mr. Horwitz. And on behalf of Wynn, should note the defendant is present with counsel, Ms. Taylor, Ms. Massoth, and Ms. Barlow. This is the time set for or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Now, really quickly, what that means is there was a motion to for continuance filed by Ann Taylor. That's the blonde attorney who's standing up right now. What she has asked is, she said, basically, due to the Dateline NBC hit piece that came out, the defense is now even more behind the ball. And when there's an argument about death penalty being on the table, that makes that they have to have had time to vet everything. And now with new information coming out released to the public, they need more time. So she asked for one of two options, essentially: either go forward with the trial and take death penalty off the table, or give us more time to prepare adequately for a death penalty. So he's going to address Hippler now, the continuance request by Ann Taylor, which is that let's postpone the trial because we need more time based on what happened.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing, and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case,
I want to pause for a minute. Look at Hippler. This is something that Hippler always has this look on his face when the defense is talking. Hand on his face, like, oh my God, shut the fuck up. That seems Hippler's MO pretty much anytime Ann Taylor is talking. It's one of the reasons why I feel like he's a little biased, because I feel like he does that far more often when she presents than versus the other side. He almost looks bored. Keep in mind also, though, Hippler has heard all of this. Everything that Ann Taylor is saying from the pulpit right now, she's already filed this paper. She's already made this argument. He already knows the argument, but she's stipulating it again for the court. So maybe Hippler's bored because he knows what the argument is. He's got to wait for her to get her shit done. It's just part of the process, but it always just bugs me. He has this kind of checked out look. All right, let's continue.
Shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years.
I wanted to address this for a minute. 68 terabytes of discovery. This is one of the things that Hippler and Ann Taylor have fought about continually, which is that Ann Taylor said, look, they turned over 68 terabytes of discovery information to the defense, and it would take a team of people years to go through that amount of discovery. Hippler's attitude is basically, one, you've had plenty of time to look at it. You had the same amount of time to look at it as the prosecution. The prosecution's been giving it to you as they get it from various sources, so you're not getting it anywhere behind where they're getting it from. And in addition, by the way, Ann Taylor, you just took on another case in the middle of Bryan Kohberger's case. So if you're so swamped for time, how did you come up with time to defend another person while you're defending Bryan Kohberger? So, and that to Hippler's case is a good point. Like, you know that I believe in the presumption of innocence until proven guilty, and I'm therefore giving extra weight and extra consideration to the defense. But to that point, when Hippler was like, look, if you're so complaining about time in this case that you didn't have enough time, why did you take on another client? All right, let's continue on.
And 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time.
So her argument there is basically this. She had filed motions previously to compel the prosecution to provide discovery in a timely fashion. So the prosecution's argument is, we've been providing it to you as we get it. You're not behind the case. But Ann Taylor has argued, no, that's not true. You're not providing discovery in a timely fashion. And she has multiple times filed complaints before the court that they're not providing discovery to her in a timely fashion. So that's what she's talking about there.
We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized.
So I want to pause. I want to pause for a minute because, again, I got a lot of commentary. This is the gist of the problem. Ann Taylor is making the argument that, look, you guys just gave me a file dump of unsorted pictures and videos and such. And basically, it's not organized in a way that is clear what the prosecution is going to use against my client. Now, Hippler's argument is, and the prosecution's argument is, that I should say, more accurate, I should say, the prosecution's argument is, and Hippler has supported, which is that it's not our job to do your job for you. So we're giving you the information as we're getting it. It's a ton of information. It's all the body cam footage. It's all the crime scene photos. It's all the hours and hours of surveillance thing. And yes, while we may look through the surveillance footage to find the parts that are pertinent to this case, you can do the same thing. It's not our job to go through all of that for you and tell you what parts, because we're looking through the same data that you did. Now, a counter argument to that is that the state has traditionally a ton more resources than the defense. The state has multiple law enforcement agencies working on it, FBI agents, Moscow police agents, county agents. There are all kinds of agencies working, including the prosecution team. They have more resources at their disposal, so they can put more eyes on it. The defense team is a smaller group of people, so it's not a fair playing field. And that's part of the argument. This is part of the reason why, in my opinion, that the legal system, it puts the presumption of proof on the prosecution. They have the stacked deck. They have all the cards in their table. They have a ton of people and ton of resources, technically unlimited resources, it seems like, of state dollars to fight this case and bring anything they want to against a person. So because they have a stacked deck in their favor, they're held to a higher standard. That's why the burden of proof is on their part to prove Bryan Kohberger guilty beyond a reasonable doubt. It's not the defense's job to prove he's innocent. It's the prosecution's job to prove he's guilty because they have a stacked deck already. All right, let's continue on.
Also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced.
Let's stop for a moment. And this is an educational platform. I like to try to educate people on how things work. So let's talk about the grand jury indictment. And I realize we're going to be way behind. This is why. those of you with FOMO are like, oh my God, devil's advocates, would you let me listen to the feed and we'll talk about it later? No, this is why we're recording it afterwards. So a grand jury's purpose is to be convened before trial begins. A grand jury basically looks at the evidence that the prosecution has and determines whether or not there's enough evidence to basically waste everyone's time and money, taxpayer money, proceeding to trial. If it's determined by a grand jury that there's not enough evidence, that it's fruitless, and then it's a waste of everyone's time and we don't go to trial. A grand jury, therefore, is not determining guilt. They're not determining anything other than, is there enough evidence that we think a jury should have to look at this and decide amongst his peers whether he's guilty. It's just a determination of, is there enough evidence? Now, grand juries typically are convened in private. It's outside of the public eye. No one sees it. And the defense also is not at the grand jury testimony. Most of the time, I believe, if not all the time, but most of the time, the defense is not part of the grand jury. They don't get to provide arguments. They don't get to argue the prosecution's stance. They don't get to say, hey, you just presented a bunch of stuff to a grand jury that's not relevant, and here's why it's not. That's not the purpose. The grand jury gets to see a one-sided view of the argument. Here's all the reasons why we think Bryan Kohberger is guilty. Do you guys think it's enough to go to trial on and hear the defense's argument? That's the purpose. Now, when that grand jury is done and they've convened and they've made an indictment, so that's one of the jobs of a grand jury, is to make an indictment. So they look at the evidence and then they indict a person or not. Indicting means a grand jury looked at the evidence the prosecution has and thinks, yes, there's a strong enough case that we want to hear the defense's side. Otherwise, they would say, no, this is frivolous. We don't need to go to court. The prosecution has a shit case, right? So we believe already at this point, for those who are keeping score, that the grand jury has already been convened. Various people that we all want to know what their testimony is, such as Dylan Mortensen and Bethany Funk, they have given testimony to a grand jury. They've given testimony that we don't know about and we haven't seen. All of that testimony, all those things that happened were done in secret, essentially, even outside the eyes of the defense. When it's done, the defense is supposed to get a full copy, essentially, of the discovery of that grand jury testimony so they can know what was said and what was presented to a grand jury that made them decide it was worth going to trial on. Ann Taylor is arguing here, it took me a long way to get to it to tell you this, Ann Taylor is arguing here that they had to fight and fight and fight just to find out what the grand jury saw after it was done. So again, grand juries, the defense doesn't see it while the grand jury is convened up to the point that they give an indictment. Once they give the indictment, that becomes part of discovery, and the defense is supposed to be able to look at what did the grand jury see. All right?
Issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that.
We need to talk about IGG briefly. IGG is the investigative genealogy or genetic genealogy information. IGG, investigative genetic genealogy. It is basically the DNA evidence that links family trees to the crime scene. So again, Bryan Kohberger, the DNA on the knife sheath was traced through genetic genealogy databases like Ancestry.com, 23andMe, these kind of places. There are versions of those ancestry databases that are permitted for law enforcement to use, and other ones whose terms of service say that law enforcement will not go into those databases. We know law enforcement went into databases like Ancestry and 23andMe that they are not supposed to go into. Their user agreements say that when people use those sites like Ancestry, they're not giving permission for law enforcement to search their DNA, and yet they did it anyways. So whether or not that's considered illegal or just unethical or whatever, there's a huge fight in the court system, and has been for years, about how the government came up with the IGG information and what databases they went into. And so there's been fighting over that. In addition, what Ann Taylor is trying to point out is what happened was, and I'm going to try to be brief, Othram Labs was contracted by the Moscow Police Department to develop a profile and on the DNA that was left at the crime scene. They could not come up with a name. They came up to a family tree of 4 brothers that were not Kohbergers. The FBI then, who had been working with the Moscow police since day one, said, let us take over the genetic genealogy stuff and we'll find it. And then they went into extra databases that law enforcement's not supposed to go into, and they developed a hit to Bryan Kohberger's family back in Pennsylvania. That's ultimately the summary of how it happened. So the defense said, We need to know how you exactly developed that profile getting to the Kohbergers in Pennsylvania. And that has been suppressed. The judge has basically allowed the prosecution to say, sorry, that's law enforcement tactics. We don't have to show you. And civil rights experts will tell you, yeah, you do have to show us. A person has every right to see the evidence that was presented against them and to challenge the evidence. You saying that we don't have to show you how we developed the name Bryan Kohberger or how we got to Bryan Kohberger's family in the databases that we weren't supposed to use, that just saying that's law enforcement secrets, that is a violation of Bryan Kohberger's constitutional rights. He has the right to see the evidence and how the evidence was gathered, and they're not letting him see that, not letting his defense see it. So all of these fights are going to be grounds for appeal when we go to court.
That's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025.
And just for a record, Ann Taylor is basically saying a whole bunch of shit that you guys are doing is unfair to Bryan Kohberger. The discovery is not being done in a proper fashion. You guys are hiding information about how you developed the case. And she's asked multiple times, at a minimum, with the way that this is being handled, at a minimum, you need to take the death penalty off the case. Because again, when death is on the line, never get an argument for failure when death is on the line. All right, I can't help myself. When death is on the line, there's a higher standard. So already they're not meeting the standard for Bryan Kohberger's defense as it is by giving everything they need. But when you're going to put somebody to death, you need to give even more data. It's the prosecution's held to a higher standard when they want to put somebody to death. So she's argued over and over again, take death penalty off the table because you're not giving us the minimum requirement information, even for a regular trial, much less a trial that includes death penalty. And all along the board, Hippler has said, nope, not taking death penalty off the table, not taking death penalty, because Hippler wants to see Bryan Kohberger executed. That's my interpretation. He refuses to budge on taking the death penalty off the table. And so those who are guilters, of course, will say, of course, this is the Hail Mary plan by the defense to get death penalty taken off the table because they don't want to see him get killed for what they know he did. When in reality, what she's saying is, anytime you're going to execute somebody, you're held to a higher standard, and we're not even getting the minimum standard of information for defending anybody who's not facing the death penalty. So death penalty should be off the table entirely. Anyways, there we go.
Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed, and that comes from State versus Creech, 105 Idaho 362 at 383.
This statement that she's making is a common phrase in legal terms. Death is different. That's what she's quoting the case law where they basically where Supreme Courts and stuff have indicated death is different. When you have death penalty on the line, it's not a normal trial. It is held to a higher standard when death is on the line. So that's what she's saying. Death is different. And you noticed, I don't know if you noticed, but if you go back and, if you had a bigger screen and I was playing this full screen for you, maybe you'd see it better. Hippler kind of I don't know, I wouldn't say rolled his eyes, but he is well aware of the argument, death is different. So when she started to quote the case law for him, he's just like, yeah, okay, I get it. Death is different. So that's kind of the attitude I got from Hippler, was like, he knows exactly what she's going to say. And she's got to quote the case law. He knows the case law. He's well aware of the precedent. Death is different. He kind of rolled his eyes. I don't know if rolling his eyes is the right thing, but he's just kind of like, I get it. Go on,
Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. An effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts.
So earlier I talked in the preamble of this video about the two phases. She talked about the merits phase and the penalty phase. So I called it the guilt phase and the punishment phase. Merits and the penalty phase. So the merits is going to be the main part of the trial. It's going to be, did or didn't Bryan Kohberger do it? Is he guilty or not? Yes or no. Then if he's found guilty, they will go to the penalty phase where they'll discuss, and what is the penalty? Is it life imprisonment without the possibility of parole, or is it the death sentence?
Are guided, and counsel's guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524, said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation.
Technically, this is something Hippler already knows. He knows all of these cases. Not only that, but when they wrote the motion to basically remove the death penalty, they cited all this stuff before. So this is part of the reason why you see Hippler kind of checked out. He's already read all this stuff. He's already reviewed all this stuff. He's known it from other cases. It's all boring stuff. But for the court record and for the jurors that are sitting behind them, for some of them, this is the first time they're hearing it. People are probably taking notes and they're writing down. This is the first time they've heard it. So it's boring legal shit for the judge, but necessary for the record to cover this stuff. But he's already read all this stuff, and that's part of the reason why he's a little checked out, I think.
In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state.
So what Ann Taylor is pointing out is, again, when death is on the line, death is different. They are required, the defense is required to exhaust all avenues to a greater extent than in a normal trial. So she's repeating to him, reiterating to him, when you start coming up with new information and new leaks and new data, we have to go down all of those rabbit holes. Now there's new rabbit holes we have to go down. So all of that has to be investigated. It's a requirement of a death penalty case.
That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet.
Wow.
Considering what's required.
So here we are. We're a month away from going to trial, and Ann Taylor is admitting that just this week she's received new discovery. So they've had stuff, and part of that may be maybe the DoorDasher, right? So now we found out recently that the DoorDasher is going to be on trial, and Molly is going to go on trial as an eyewitness saying she saw Bryan Kohberger there. And this seems to be newer information that people are talking about, that she's going to go on trial. So did Ann Taylor get new information about that now just this last week? And again, as discovery is coming in, they have to have time to fully vet that kind of stuff, especially when death is on the line.
Required at a penalty phase in a capital case. We're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors.
Now, what I think she's talking about there is important. And again, educational purposes. The defense has argued that Bryan Kohberger has autism spectrum disorder. It makes him look a little flat. It makes him look like he doesn't react to things the way that you and I normally do. People who are on the spectrum don't have normal reactions to things. That they don't tend to get humor like we do. They don't tend to get sarcasm like we do. They take things a lot more literal, and they're more matter of fact. The fact that Bryan Kohberger has, for example, autism spectrum disorder, according to the defense, is something the jury needs to know. Hippler has indicated that no, they don't need to know that, except for maybe at the penalty phase, just before they've said he's guilty, but they're going to put him to death. Then maybe at that point, it's appropriate to find out that maybe the reason why he looks so cold in the courtroom is something you should consider before putting him to death, but not during the penalty phase, or not during the merits phase of the investigation or the trial. So she's arguing once again that in a death penalty case where death is on the line, the jury needs to know from the outset that Bryan Kohberger is on the spectrum and that he performs certain ways, and there has to be people who can speak to his character and his history of this condition, so that the jury is fully aware that this is not the eyes of a killer or the indifference of a killer, but rather a condition that he's going to look different than you and I are used to seeing people react, because he's on the spectrum.
That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case, should the case reach that phase. And they rely on understanding family history and Mr. Kohberger's own history.
So she's admitting that they have experts on hand ready for the mitigation phase. So again, merits phase is the main part, and if they've just find him guilty, then they'll go to the mitigation phase on what we should do about it. They've got experts already on hand to deal with that during the mitigation phase.
They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day.
So, excuse me. I got to choke. So it sounds like Ann Taylor is having problems interviewing and getting cooperative witnesses or whatever that have knowledge of the case. Is that family members of the victims that won't talk to the defense? I don't know. Is it just people who are not available? I don't know. But apparently the judge is aware that the defense has had some issues getting a hold of some witnesses, and they need to fully be able to talk to all the witnesses in the case. So it's interesting to think about who those people are.
The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now,
Patterson's
to be
book.
followed by a docuseries on Amazon Prime.
Actually, I think it's in the other order. I may be wrong, but I think the documentary comes out and then Patterson's book. But she's saying it's Patterson's book's coming out and then the documentary. Either way, Patterson's name's on both the documentary on Amazon Prime and the book. I've already pre-purchased the book, by the way, because it's my job to stay up on the story and the hit pieces and all this stuff like that. So some of you are like, I would never buy that piece of shit article that's in a book that's clearly going to just say Bryan Kohberger's guilty. I get it. Don't spend your money on that. I will selfishly say, watch my breakdown of the book. I'll read the book to you chapter by chapter, so you don't have to buy the book and give James Patterson and his hit cronies the money. I'll even watch the Amazon Prime video for you so that you don't have to watch it and give them the airtime. Instead, gratuitously, you can give me some of your airtime, and hopefully you'll trust my analysis of that book and that documentary. But I'm surprised and I'm excited. I said at the beginning of this, I wasn't sure they were going to bring up the book. And well, actually what I said was, I'll be surprised if Hippler stops the publication of the book or the hit piece coming out on Amazon Prime. I don't know that he's going to address it, but it's interesting that it's coming up in front of the court now.
There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that
I want to point out a legal quandary I think we're getting in. I think I need to have my attorney friend on to verify how I say this, but we have a right to a fair and speedy trial. They can't just keep Bryan Kohberger in prison for the rest of his life because we keep having to wait a little longer for information to die down and for the media to die down and whatever. He can't be held indefinitely while we wait for the temperature to cool down in the public. So when Ann Taylor is putting this idea out that, hey, look, we need a continuance for some of this recent history to cool down in the public eye so that it's not everything we're talking about. On the other side of the coin, you can't just keep somebody in jail forever because you need time to cool it down. So it's going to be interesting to see how that pans out. Because again, Bryan Kohberger has a right to a speedy trial, and just sitting around waiting because hit piece after hit piece keep coming out and it delays his trial is not fair to him as well.
Jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
All right, let's stop. So Ann Taylor has just finished her presentation to the court why we need to continue, meaning postpone the trial. Now, as a person who's got essentially plans on the books to go to trial, I'm kind of hoping we don't postpone it. By the same token, her argument is it's not fair to Bryan Kohberger to go to trial and seat a jury when literally a new book's coming out, a new hit piece right when we're getting ready to seat the jury. So I'm excited to see what's going to happen next. I think the prosecution is going to have a chance to respond, and then the judge is going to make his ruling, which includes, I think, things that he's already decided. I bet you when Hippler came into the courtroom today, he already knew what the argument was going to be on both sides, even though they're technically going to say it again in front of him. He's already decided what he's going to do about the Dateline NBC piece. He's already decided what he's going to do about whether to postpone the trial or not. He's just hearing the formal argument, but I believe Hippler has already made up his mind, and this is all just formality. So I'm excited to see how it plays out. Let's continue on.
May I, Your Honor?
Of course.
So here's the prosecution, not Bill Thompson, oddly enough. It's his other co-counsel. I don't know if it's oddly, but his co-counsel. So the main prosecutor, I believe, is Bill Thompson, sitting back there at the table. He's having his other co-counsel do this presentation. So let's check in here. Oops, I got to click on the right button though. And of course, the argument here is going to be.
Thank you, Your Honor.
Nope. Let's go.
I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction.
So I said something a little bit wrong that I need to clarify. So the penalty phase, which is determining what the penalty is a little different than the mitigation phase, which is that mitigation phase is, okay, so you've decided the penalty should be merited, but what are the mitigating factors? What should you consider before handing out that sentence? I.e., my client has autism spectrum disorder. Before you put him to death, that is a mitigating factor. It's something that should weigh in on your decision about before you render this verdict or a punishment. There should be mitigating factors discussed. So there's a little bit of difference between mitigation and the penalty phase. And I think I may have misled you a little bit earlier on that, but that's what we're talking about here is the mitigation part.
The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
Clerk needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start.
This is an example, by the way, of what the difference is between me being in the courtroom and you watching a live stream. As you can see, he's using an Elmo. By the way, I worked at a school district. We used Elmos all the time. That's how teachers they would use that to broadcast or to display a picture, a piece of paper, to the screen on the wall for the students to look at. So they're using an Elmo, this basic, really cheap document camera, to present. But here's the difference between live streaming on the internet that you guys can all see versus being in person. If I was in the courtroom or even in the overflow room, I believe I would be seeing the piece of paper that they're talking about on the wall, and any piece of paper like that they're going to show on the wall, including photographs, images of the crime scene, and stuff like that. We're not going to see that in these live broadcasts. You're just going to hear them talking about what they're seeing. So that's the benefit of being there in person. Why? Also a benefit for you to watch my analysis if I get to attend in court like I'm planning on, because I'll be able to tell you, at least from my perspective, what exactly you saw and what my opinions over those are.
My discussion with them, I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness, and the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics.
Right there, Hippler again he's always, in my opinion, more supportive of the prosecution. So the prosecution says, hey, look, Ann Taylor's not giving us all the information. And he's like, yeah, it's really hard for you guys to do your job if Ann Taylor's not going to come pony up. She makes the argument that they're not doing their job. Does Hippler ever say the same thing? Yeah, Ann Taylor, it's hard for you to give a good defense if the defense isn't going to, or the prosecution's not going to play right. No, Hippler always comes in with that kind of shit, it seems like, which is, yeah, I can understand why you're having a hard time because Ann Taylor's being a bit little bitch. That's my interpretation of Hippler's attitude.
Specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to.
I'm going to run that through the universal translator as I understand it. So what he's basically saying is Ann Taylor is setting up a crap ton of witnesses and exhibits during the mitigation phase with the anticipation that she's going to appeal the shit out of the conviction and the penalty of this case. So in other words, he's saying she's just setting up the appeals before we even got to the conviction part, is kind of how I interpret what he's saying.
Actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, excuse me, to prepare for trial, there is no basis for a motion to continue. Now let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will.
By the way, before we get into the media coverage, to be fair, Hippler's got his hand on his face, looking checked out during the prosecution as well. So I just want to point that out because, I pointed it out when he was doing it to Ann Taylor. He's doing it to the prosecution as well.
Pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place if there's a continuance. What seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating.
Hippler's checking his watch. Are we gonna get done with this shit? Hurry up! Because again, I think Hippler already knows how he's gonna rule. He's just like, hurry up, let's get this done so we can go to lunch. Which is funny because actually this came in just before lunch. So, anyways, point being, looking at his watch was kind of funny. We'll go on.
In this motion, 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendants
I have.
forensic psychiatrist, and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course.
Now that's interesting. And I don't know. I'm going to make a guess on something kind of big here. So recently, the defense offered a proffer for alternative suspects. So they came up with a list of a person or two that are alternative suspects. And then the judge asked them to provide the information that proves that this is not just a frivolous name that you're giving us, that there's meat behind it. That information looks like it's been turned over to the prosecution when they offered the proffer of proof of alternative suspects. So we know, so the defense is saying, hey, look, there are other people who could have committed this crime, and it's not just a random, it could have been somebody. I think it could have been Bob, Sally, Jim. Those are random names, right? And here's the evidence why we think it's important. They gave that information to the judge and the prosecution, and then the prosecution recently was looking into the people that the defense has identified. That's what it sounds like to me. So the prosecution has recently looked into the names and the evidence that the defense has provided as alternative suspects, and they went and did their own investigation, looking up and following up on those leads. And that investigation into the defense's investigation is the new information turned over. That's what it sounds like he's saying. So he's like, okay, look, she's bitching about how she just got new information in this case just this week, but literally it's in response to her recent submission of alternative suspects. That's my guessing of what he's going with that.
To occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
All right, so here we go. As far as I understand it, this is going to be the moment when Hippler is going to make the announcement. Everybody in America, including myself, now those who are watching live already know what the answer is because I'm behind I'm running motor mouth. I'm behind. Here we go. Let's see what Hippler says.
Any reply?
Yes, thank you.
Oh, okay. Well, before we get that, we got to go Ann Tyler rebutting that.
I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records. Bryan Kohberger passed.
So now it sounds like this is not necessarily about the alternative suspects. It's about mitigating circumstances regarding Bryan Kohberger's mental health potential issues, and that they don't want to talk to the defense, so they're having problems. That's interesting.
It's treatment records of Bryan Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court.
In federal court.
Which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high-profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
Unfortunately, I don't think Ann Taylor is the best at getting her points across, in my opinion. She's just, I feel like she could do a lot better job. And that's the thing. I have a complaint about this, but what are you going to do? I mean, she's the public defender. So like, but it's just, I don't know. Watching her sometimes, I wish she would hit things harder and better, but it is what it is. Let's see what happens. Looks like he's looking over his already written notes that he plans to speak to you about and just making sure that anything he's already decided to talk about hasn't changed based on what he heard.
All right, I'll take the matter under advisement and get an opinion out in short order.
Not going to rule on it today. Okay.
In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated.
There you have that.
All right. Is there any other matters that we need to take up?
So, I mean, all that talking, and Hippler's basic answer is, I will give a more official ruling later, not right now, but be prepared to go to trial, because more than likely what my answer is going to be is we're going to trial on the same dates. So that means jury selection July 30th. That means trial starting August 11th, which I expected was going to be the case.
In the public session before we break to go to the private session.
So again, there's a public section and a private section. So there's some things that the public's not allowed to hear. There's certain things that are going to be done, and they're about to. So they're going to continue on after the live feed cuts. He's just asking now, is there any more public pieces before they go to the private? So when the private happens, of course, we're done, and I'm going to do some editing, and we're going to put this up on you for you to watch. But there will be more things going on behind the scenes that we are not going to see.
Nothing further in the public session, Your Honor.
Your Honor, I don't believe so.
All right. We'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
All rise, please.
And that is it. That is it. The private session, I don't believe would be aired, even though it says the court is on break. I don't think we're going to come back to that feed. So I'm going to cut the recording here. You heard it. It was very, very lackluster. I had so much high hopes that we were going to hear a ruling on that Dateline NBC hit piece, and maybe identifying who exposed it and what repercussions were happening. Absolutely nothing about that whatsoever. It was purely letting the judge hear what has already been filed. Like, it's almost like a pointless hearing, it seems like to me, because Ann Taylor already submitted her in writing all the arguments why there needs to be a continuance. The prosecution's already responded in writing why they shouldn't continue it. And all they did is sit in front of the judge and say the same things that are already in writing. And he basically said, I'll give a ruling about it later. I don't understand why you don't already know what your ruling is. But be prepared to go to trial on the case that on the schedule we've got, because that's where we're going. Hippler wants this done by Christmas. We're moving forward. Ann Taylor's argument that normally it takes longer, 3 years for a death penalty case, as Hippler said, that's in a federal case, and the federal cases are notoriously slower. So we're not on a fast pace. So basically, he's telling everybody, I'll take everything you said under advisement. I'll double check everything. I'll cross my T's and dot my I's and make sure that I'm doing the best I can. But I would be, if I were you, be prepared. We are going to trial on the exact date that we said we're going to go to trial. So my plans for travel to Boise, Idaho are intact, people. So there you go. You probably heard me talk as much as the lawyers talk on this. Hope that you enjoyed my analysis and my breakdown. Some of the things I think I misled you on a little bit with the penalty phase versus mitigation factors that I kind of need to clean up a little bit for you. I apologize. I'm not a lawyer. I'm not an attorney. I say that all the time. I do have attorneys on my show from time to time to help me kind of work out some of those things. I'm pretty good at breaking down the law for you and explaining things in layman's terms. But from time to time, I get some wording off and I say things in things correctly. I was obviously wrong also as well, that I don't know if I was obviously wrong, but the idea that the defense, when they submitted their proffer for alternative suspects, but that was what the prosecution was talking about. We just recently interviewed people that you told us about, and that's what we gave you. That doesn't seem to be the case. They seem to still be talking about mitigation factors, which is the whole, once we get to a penalty phase, we're going to talk about whether or not there are mitigating factors, like Bryan Kohberg has mental disorder of some kind that should be factored in. And in fact, the prosecution even said, I thought this was all about mitigation, about the mitigating factors. So it's not so much, unfortunately, like I thought, about the Dateline piece. It's not so. It is in part about the, are we going to have a continuance? Are we going to postpone this trial to next year? It doesn't look like we're going to do that. We are on pace, and I'm going to that court if I can to get my little happy ass into the overflow courtroom. I've already ruled out that I'm going to get in the court, but I actually can. There's a possibility. I'm going to submit my name, and a certain number of seats are going to fill up in the courtroom, and then a certain number of seats are going to fill up in the overflow room, and the rest of us are going to sit at home in our underwear and watch it on TV with you, which I might be doing from Boise, Idaho. So we'll see. But in the meantime, thanks for watching Devil's Advocates. Hope you enjoyed my analysis. Hope that I can continue to do this format if you liked it. And then I'm crossing my fingers that this recording all came out right, because it's the first time I've tried to do this. Catch you guys later.